Dr. Justin Rice testified. He's an emergency medicine physician and he treated John O'Keefe on January 29th. Lally showed him a transcription of a medical chart that Dr. Rice dictated, as well as a code sheet put together by the nurses. From the code sheet, Dr. Rice was able to say that Officer O'Keefe arrived at 6:47 a.m. He was unresponsive and intubated. CPR was in progress along with ventilation. Cardiac arrest means his heart's not pumping independently, and in O'Keefe's case, there was no electrical activity. They talked about the term asystole, and that means the complete absence of electrical activity of the heart. And by the way, I'm wondering if we're going to find out soon what happened to John's clothes. There was some question or issue about the chain of custody of evidence at the beginning of the trial, and we still haven't heard that followed up on. The doctor talked about advanced cardiac life-saving guidelines. He said that epinephrine is part of the treatment. It increases the pressure and electrical activity in the heart. Lally asked about hypothermia. The doctor said that John's temperature was 80.1. Lally asked what would make your temperature decrease, and the doctor said cardiac arrest would make your core temperature decrease. He also said 80 is very cold. Lally was trying to get him to give a very clear number on when hypothermia becomes a diagnosis, but the doctor wouldn't give him a specific number. Dr. Rice said medical staff used special warming blanket, warm IV fluids. The goal was to rewarm the body and hopefully the heart would function better or start up again in a warmer environment. They continued their efforts for a good half hour, but even in spite of that, there was no significant warming of his core temperature. It sounds like he was already gone before he even got there. But I'm not a medical expert, so I don't know. But I know there are doctors out there who listen. Officer John O'Keefe was pronounced at 7:50 a.m. The doctor said that asystole and cardiac arrest persisted throughout the course of treatment. And I'm going to bring up here that Jen McCabe went into the Albert house and said John's dead. At least that was the testimony. So how does she know he's dead? Karen Reed was saying, is he dead? Is he dead? Still referring to the documents in front of him, the doctor said the physical exam showed his right superior orbital region had a 7 millimeter laceration on it, and there was swelling of the surrounding tissue. He said the abdominal area was atraumatic, meaning there's no big trauma to his abdomen. There were what he called superficial abrasions to his right forearm, and Lally asked, what do you mean by abrasions? And the doctor said scratches. And it's funny because there was another witness of whom the defense asked what he meant by abrasions, and he was saying scratches, and there was the guy who said furrows. It was furrows, he said, and Lally was objecting to that. John's Glasgow Coma Scale was a 3, which is the lowest you can get. And you know, they didn't say anything about the back of John's head. He had a contre-coup injury, and that's significant. In respect to Karen Reed, the doctor was again going off of documents. Reed's first posted vitals were at 7:51 a.m. and she was there due to a section 12. And Rice testified that in a situation where there's a section 12, his involvement is pretty variable in those situations. And Lally was asking about the protocol for that. And Rice said, well, the person would be evaluated by a doctor or a nurse practitioner or a physician's assistant. If necessary, the person would receive further mental evaluation. And Lally was asking if there would be reasons for blood work in the case of a section 12. And the doctor said yes, sometimes, to make sure there's no medical emergency. And if you think the problem is due to something else, such as intoxication, they might do a blood test. And Lally was leading. You know what? I'm going to just nickname him Leading Lally. That's his new nickname, Leading Lally. He wanted the doctor to say that blood work is just a routine part of the procedure of the Section 12. Well, the doctor was hesitant to go along with him. He wasn't going to come right out and say things the way Lally was framing them because they weren't precise. And the other thing I notice every time there's an expert witness is that a layperson, in the sense that we're talking about a lawyer and a doctor here, right? So somebody not trained in the expert's field will ask questions and try to use terminology that the expert knows, and that terminology has a very specific and sometimes very nuanced meaning. And so the way the question is phrased, it doesn't make sense, or even answering the question in that manner wouldn't produce an accurate response. Scientists like to be accurate. Anyway, so Lally couldn't get him to say what he wanted. Eventually, Lally asked if there was blood work done on Reed. And so the doctor's looking at the report. He says yes. And the result was 93 for alcohol. And that means 93 milligrams per deciliter. Well, on cross, it comes out that Rice did not make the notes on Reed's treatment. So why is he testifying to Reed's treatment if he's not the author or the custodian of these records? He said he does not recall treating Reed at all. He does not recall writing a note. He does not recall ordering blood. He does not know who collected, packaged, or sent blood to the lab. He himself did not collect blood, and he wouldn't. He did, however, treat John. And Little was asking him if any firefighter or EMT said anything about John being struck by a car. And you know what? Lally objected. Well, earlier in the trial, Lally wanted the jury to hear that. Anyway, he was allowed to answer, and he says he doesn't remember that. And he had no recollection of anyone telling him that his patient had been in a car accident. But then he said he thought there was a note somewhere that he made per an EMS report that one of the medics said maybe the patient had been struck by a vehicle. But he didn't have any notes from that in front of him. So Little pulled it out and showed him the report and let him look through it. And he said, yep, that refreshes my memory. Well, guess what? There was no mention of a vehicle and no mention of a patient being struck by a vehicle in his notes. And I want to point out something else here again about memory and testimony. I do not believe that this doctor was lying. Memory is not perfect. The man is not lying. It's just memory is funny like that. So there's nothing that said that anyone told medical staff that the victim had been or was potentially hit by a car. Little asked about O'Keefe's injuries, and she said aside from his right arm and his eye, there were no injuries on him from the neck down. And at first, the doctor didn't seem to want to just wholesale agree with this, so she went down the body. There were no injuries on his shoulder. No. His torso. No. His back. No. Hips, ribs, knees. And when they said knees, he said, actually, he even noted there were no injuries to his knees, shins, ankles, feet. If you got hit by a car, depending on the height of you and the height of the vehicle, you're going to have injuries to those places. If you were dragged underneath a vehicle, undercarriages can do a lot of damage, right? There should be injuries to all of those areas. Now, Little didn't ask him this or get him to say any of this, just got him to confirm that there were no injuries on him aside from that arm injury and the eye injury, except there's still that big gash in the back of his head, but maybe they didn't see that. I think maybe it was just worded wrong, because this surprised me. She said there was no fracture reported from the neck down. Well, the guy is not breathing, so they're not sending him to x-ray. On redirect, Lally brought this up and said, you saw no fractures, but did you want to explain that? And the doctor said, well, yes, our focus is on core resuscitative medicine. He said the focus is on things pertinent to resuscitative effort. And really, everybody out there who's taken first aid and CPR, just think of your ABCs. If the person is not breathing, you're not going to worry about a broken arm or something. You're going to worry about the breathing first. Lally gave him a chart to refer to, and he confirmed that John suffered cardiac arrest, head trauma, and exposure. The next witness was Gary Fowler. He's a pathologist. And again, Lally was asking him about standard tests. Lally wants to get somebody to say that blood work is a standard thing if you go in for a Section 12. Well, Fowler isn't going to say this. What he does say is, well, it depends on what the primary care doctor is thinking. And some common tests would maybe include a CBC, and he listed a few others, and none of them were alcohol. But we need to back up for a minute, because who was the primary doctor for Reed if it wasn't Dr. Rice? So Lally puts it another way, trying to get him to say what he wants him to say. And Fowler says tests for alcohol and drugs are not routine. If a primary care physician has a concern, he may order such a test. And again, he says alcohol is not a standard test. Lally asked for Section 12, would it be a usual process? And he says, I don't know if that's a usual process. In respect to policies on blood alcohol concentration, the witness said the phlebotomist uses the same process but doesn't use alcohol swabs. So they take the blood the same, but they don't use the alcohol swabs. And the policy is to never use alcohol swabs in the ER or when the test is for alcohol. And he even said the supervisor removed almost all of the alcohol swabs from the ER. And he said twice, almost all. And he said, and that is in case the phlebotomist forgets. Lally shows a medical record of Karen Reed's, and the witness reads out 93 milligrams per deciliter. Lally asked about the process for this. The witness said, first, the doctor orders it. Well, Dr. Rice said he never ordered a blood test for Karen Reed. So what's happening there? Was there a mix-up? Who ordered it? They should have records, so we should be able to see that, yeah? After the doctor orders the test, there's a label printed for the tube, and it includes what's to be tested. The phlebotomist locates the patient, asks the patient to confirm their identity, draws the blood, puts the label on the tube, initials the tube, writes the time on it, brings it back, and then it goes through a chute to the lab. The lab scans the barcode. The tech manually enters the time. The tube is centrifuged. Then the tube is brought to a machine, and the machine does the test. And Lally gets him to describe the centrifuge, and Lally asks about the difference between whole blood and plasma, and which would record a higher concentration of alcohol. Well, the answer is that the plasma would. So the doctor's saying once you separate out the blood, that liquid part is where the alcohol would concentrate, and that's the part they test. So this is not the same kind of thing that you hear when you hear about the test they do to determine, say, whether you're driving under the influence. Lally asks about conversion and what the conversion would be in whole blood. And the witness answered, we are not in the business of legal testing. We don't make conversions. And they kind of go back and forth a little bit. And the pathologist says, in order for us to be doing that, we would have to do many tests to validate it. He does agree that he knows about mathematical formulas for this. Well, this is different from validation. And the witness said there are varying opinions on what formula can be used. He testified, according to documents, that the test on Reed was ordered at 9:03 a.m. and the blood was drawn 10 minutes later. Well, who ordered it? On cross, Little asked him if there's a difference between screening, say at the hospital, and forensic tests for alcohol. The witness agreed the hospital uses serum, and that actually doesn't measure alcohol directly, but it measures the byproduct when the body breaks down the alcohol, this NADH. And he also agreed that NADH can be altered if the patient has increased lactic acid or LDH and other things as well. And if I mangled that, one of you medical professionals out there can let me know. The witness said that the machine that they use can catch some of these things. Little asked if trauma or loss of muscle could cause interference in this test or alter it. And he said he hadn't read the studies that she was referring to. She asked if some interferences might not be picked up by the machine at all. And his answer was, if that happened, it wouldn't be a common thing. And he added over 80% of hospitals use the same method as his hospital, so he doesn't think they'd be using it if there were any major problems. And fair enough. They do a lot of testing on all this stuff, and for the vast number of tests, it's great, it's fine. I think the problem, and what Little is getting at, the problem is the outliers. If you don't fall within the reference range, then interpreting results is going to be different. The laws are based on the whole blood test rather than the serum test, and the hospital doesn't do the conversion. He agrees that the test does not establish when alcohol was consumed. On redirect, Lally asks him about interferences. So did he see anything that would lead him to believe that there were interferences that could render this machine's results inaccurate? The pathologist said, well, from the chart, he didn't see any interferences. And then it comes out, the machine flags 3 common interferences, not all the interferences. And as for looking at the chart, and remember, this doctor did not treat Karen, so the only thing he can do is look at the chart, right? So you can't blame him. But the chart was for a mental health screen. So all her other medical issues, are they all on there? This was a mental health screen. So, you know what? No, there's not going to be information on there that would give him any kind of a reliable answer here. That was it for that witness. The next witness was Nicholas Roberts. He was working at the Massachusetts State Police Crime Lab in toxicology. He has degrees in forensic toxicology. At the time of this incident, he was an F1, which meant he was in training. But really, the guy's got a couple of degrees. It's not like he's qualified. It's not like he doesn't know anything. In May of 2022, he was assigned to serum conversion. He received results from the hospital. So these are documents, right? They're not the actual samples. Hospital tests serum, which shows a higher concentration than the whole blood. And he said he was the person who converted Reed's numbers. And that was May 3rd, 2022, from the hospital medical records. Basically, he's got limited information. So because he didn't do the original test, he's not like her doctor or something. All of the potential things that could have interfered are not taken into account. He said the number he used for the conversion was 93, and he used the time of 9:08 a.m., which is when the blood was drawn. He did a retrograde extrapolation, and in order to do that, you need the time of the last alcohol consumption. Anything shorter than 2 hours, they don't do the extrapolation. And he talked about there being a well-known metabolism route for alcohol. He says the first drink, you're absorbing alcohol, and it will steadily increase as time goes by. Once all of the alcohol from that drink is absorbed, your alcohol level plateaus. And if you don't drink any further, you begin eliminating, and the levels gradually decline. In order to calculate this retrograde extrapolation, the information he relied on was the police report to determine the time of Reed's last drink, and that's what he used for the calculation. And the time that was listed on the police report was 12:45 a.m. Now, that's interesting. They left the waterfall at midnight. Are the police suggesting she went somewhere else and drank some more? I'm wondering why it's 12:45. Maybe we'll hear about it. He said they do round to the nearest interval, so 10 or 15 minutes inaccuracy in the initial number he's given won't change the results a whole lot. Hours though, yeah, that would. He said they calculate a minimum and a maximum. They allow this 2-hour period for absorption. They know the elimination rate of different people, so they include the lowest and the highest numbers based on studies showing these elimination rates. But I have a question. Do the studies include people with this individual's medical issues? Do they include people who've just gone through trauma? Anyway, he said that for Reed, the range was 0.135 to 0.292. So that would be his calculation for whole blood instead of serum. And Little discussed with him that that's a pretty wide range. And he said, yes, it would apply to the general population. Would it apply to cancer patients? Little said, you're relying on assumptions in respect to metabolism, that something will continue the way it's always continued. And his answer was, hey, metabolism has been well studied. And she said, in order for you to come make these calculations, certain assumptions are important. And he said, yeah. Little asked, if the drinking pattern is different, then the entire calculation would be incorrect. And the witness agreed, yes, it could be. And Little brought out the fact that no actual testing was done by the crime lab. Therefore, the actual testing doesn't fall under the crime lab's accreditation. Now, the hospital is also accredited. And through this witness, Little was able to point out that the accreditation for the hospital and the crime lab are different. They have different goals. The crime lab uses a gas chromatograph, and it sounds like that's not what the hospital uses. And again, even their test is actually just for NADH and not alcohol specifically. And the witness also testified that the crime lab usually does confirmatory tests. And he agreed that they're a fail-safe against false positives. Make sure no one made a mistake or anything like that. Ensure that the correct sample was tested, that sort of thing. But he couldn't do that in this case because he didn't have samples. He had a report. So he had to basically trust the accuracy of whatever was done at the hospital. Little suggested to him, it's almost impossible to accurately calculate this number for an individual. And the witness said, yes, it's an average. It's based on the average individual. And he agreed, yeah, you can fall outside that average range in terms of metabolism and everything else that would have an impact on the results. So you can fall outside of the range on the low end or the high end. And Little said, well, the more imprecise your information is, the less reliable your result is going to be. And he said, yeah, your starting blocks have to be good. Basically, bad info in, you get bad info out. And he agrees that the range that is given is large. And Little says, yeah, it's 120% swing one way or the other. The witness said that his results assumed elimination at or before 12:45. But if she drank after 12:45, the entire calculation would be incorrect. And he agreed with that. On redirect, Lally tried to get him to say that the time of her last drink was known. But again, I love scientists. This guy won't just go along with leading Lally. He says the time was based on what was in the police report. And Lally was asking, well, would there be a difference if the drink was later? And the witness said yes. And Lally went on, well, 1 a.m., 5 a.m. And the witness said, well, at 1 a.m. in this case, it wouldn't make a huge difference because it's only 15 minutes. But if it was 5 a.m., yes, that would be a significant difference. And the 12:45 time was provided by police. And that 12:45 time was not provided by Karen Reed. The next witness was Michael Trotta, Public Works Superintendent. He justified that he does typical management duties. He said early in February he was contacted by a trooper, and I believe it's Proctor. He said he didn't know the trooper, didn't know the victim or the accused or the Albert. He said the trooper wanted to know the procedure that they went through to prepare and staff a snowstorm. So he talked about how many plow routes there are and how many trucks they have. Routes are generally 3.5 miles. There are 29 plow routes plus side route. He says they try to get 2 trucks on every route, 1 town truck and 1 private. So they contract a lot of private trucks. He says the operation manager is the one who assigns the routes. And before they get into plowing, they start a sanding operation. Later, they talk about how high up you might be sitting in comparison with a car. He said the trooper was asking who is assigned to the Fairview route. And Lally shows the witness a document, which the witness says is a plow plan for January 28th, 29th. He said the first group of sanders were scheduled for 11 p.m. on the 29th. At 2 a.m., all the rest of the workforce would be coming in. At 3 a.m., all private contractors would be plowing. And at 5 a.m. is when everybody would go home. And I'm going to note here that this is the plow plan. That does not mean that's what happened. Now, I don't know if there is going to later be some discrepancy or not, but the fact that somebody's on a work schedule doesn't mean they showed up at work, or the fact that there was a plan made doesn't mean that the plan was executed. It's good reference material, it's useful, but it's not absolute as to this, and this happened at these times. Just making mention of that. Don't know if it's going to matter. He said the Fairview route was number 11, truck 30, that's a town truck, and a guy named Brian Loughran, I think I've got that right, was scheduled for there, plus 1 private contractor. Lally asked about the procedure, and the witness says, first, you decide if it's a plowable situation. And he said that you start when there's about 2 inches of snow. You plow the middle of the road first. And then Yannetti got up to cross-examine. The witness said he didn't know at the time that Proctor was investigating the death of John O'Keefe. And Yannetti says, but you knew John was found. And the witness is saying, yes. But then it comes out that the conversation with Proctor was via phone call only. So he was never asked to arrange any kind of interviews with the employees. And then he said something that I thought might have surprised Yannetti a little bit. I could be wrong. The witness said he may have discussed with Proctor who was on that route. Yannetti says, oh, you did? But the witness doesn't have a memory of the trooper's exact questions, but he does agree that Proctor asked about the plow list. Well, on this plow list, the full names of the employees aren't on there, but this witness knows the names. And Yannetti asked, was Brian Loughran mentioned? And the witness says, yeah, he may have. And Yannetti's kind of pushing. And I felt bad for the witness because I think the guy really doesn't remember. He's not going to say, yeah, I remember that if he didn't, right? And what can you do? If you don't remember, you don't remember. Yannetti's diction is percussive. So I think sometimes he comes across as more aggressive than what he may be trying to come across as. I could be wrong. Anyway, Yannetti asks about the length of the phone call. The witness says that phone call with the trooper was only a few minutes. Yannetti asks if Proctor followed up with this witness personally, and the witness says, I'm not sure. Then Yannetti was trying to ask questions about February 14th and a business card that was left with the witness by a defense investigator. And he's not able to ask. There are objections. So Yannetti says, who is Bill Walsh? And the witness says he's the operations manager. Yannetti asks, did Walsh's name come up with Trooper Proctor? And the witness says he believes so, but he's not positive. The witness confirms that Brian Loughran was driving the truck on Fairview. Yannetti hands the witness a document and says to him, compare this document with the one you have in front of you. Are they the same? And I have no idea what this is about. The witness looks at the documents and he takes his time and he agrees that the two documents appear to be identical. The next witness was Louis Jutras. He's the manager of information systems of finance department for town of Canton. Basically, he's like the technology guy. He said, after January 29th, Lieutenant Gallagher, so this is Canton Police, let the witness know that the state police would be looking for video. And subsequent to that, a state trooper, Dunn, reached out and requested anything facing Washington. And that struck me as interesting because why not cover all the potential routes? But okay. And the request was video from 12 to 1 on the 29th and 5 to 6. And this strikes me as odd too, because you want the video before and after. This is just such a narrow request. I know they can't ask for unlimited amounts, but I would expect a wider time frame than this, but okay. And this creates an issue because if Karen Reed's SUV was at Fairview at the time that Ryan Nagel was there, which was 40 minutes or more after he received the 12:15 text from his sister Julie Nagel. So that puts her at Fairview at about 1 a.m. If she leaves Fairview then and drives home, they're going to be missing a critical time. He was also asked to get video from Pequot Side farm cameras, and those things were the initial request. He said he received a subsequent request for video from the town hall and the library. The witness said all the cameras in the town are from the same manufacturers, but they're different sizes and models depending on what they're being used for. The exterior of some of the cameras he's talking about captures portions of Washington Street. And get this, all of their cameras are motion activated. And I get why companies and even cities do this, but the motion activated ones are unreliable as crap. The witness believes that the date and time that the videos were pulled would be on there, and the date and time of the footage itself would be recorded. He said the system is linked to a time server, so that's to give some confidence in respect to whether or not the times are accurate. The witness says they do get overwritten, some in 30 days, some are longer, and some get overwritten sooner. On February 7th, he got another request for footage. And he said he went through the process of retrieving the video via the manufacturer's instructions. And he sent a file share link to the police. Okay, all you techies out there, explain that to me. If you have a file share link versus a copy of something, what can and cannot be done with that? He was asked if he parsed it out, like if he separated any of it or sent it in pieces. He said he just sent the entire thing. He didn't parse it. And he said aside from him, no one has access to the footage, except he sent a link to the police. The witness said that he received notification on February 1st from the operations manager that the GPS for the plows was not working during the January 28th, 29th period. The witness said sometimes that does happen. The witness said when he was looking for video, he was not told what to look for. And he didn't actually watch the video. He watched only to make sure that he actually had it. And he looked at the video at the beginning and at the end to make sure that he was sending the whole section and didn't watch the contents. They show a video that starts at midnight and it appears there's an SUV there and you can't see the passenger light and you can't really see close up with whose SUV it is. I mean, I'm assuming it's Reed's, but that's it. And I'm wondering why that photo is introduced through this witness when the witness never viewed the contents of the video. I mean, maybe they get away with it because it's the very beginning and the witness did look at the very beginning. And then they show another still from 5 a.m. You know what I'm curious about? What other vehicles did police look for in these areas? And were there any areas not covered? And again, there's an issue with the 1 a.m. endpoint. They needed to have something longer than that. Because if Reed was at Fairview at 1 a.m., they need the video after that. On cross-examination, the witness confirmed the state police only asked for 2 hours of video. He confirmed he did not sit and watch. Yannetti asked him, was there missing footage that you know of? And the witness says, no. Well, you know what? He wouldn't know. But the point is, it's not like this witness went and cut something out, right? Yannetti says, you provided raw footage. And he says, yeah. And this footage is the footage that would have been overwritten in less than 30 days. The witness doesn't recall if he knew at the time that Karen had been charged. He was asked about conversations, dates and time frames. He said he knew there was a motor vehicle accident, but who and what? He's not sure if he knew that specifically at that time. And Yannetti brought out something that was a good point, which is, could the police ask you to have downloaded and preserved this on a hard drive? Could you have done that? And the witness says, yeah, I could have. Except there was never a request for him to preserve the evidence. Why? Yannetti asks about a conversation with this witness in Proctor on April 6, 2023, and the witness doesn't recall. He does recall getting a call from a trooper asking for a copy of footage, but he wouldn't have that anymore. So that's the copy he already gave, but he's not going to have that anymore. He's not going to see any reason to preserve it. He's not a detective. He's not in charge of this, not his responsibility to decide whether something should get preserved on a hard drive or not, or any of that. He basically gave the police what they asked for, and as far as he's concerned, I mean, it's done, right? And the witness agreed. Once the information leaves him, he has no control over what happens to it. And that was it for today. No huge drama, but certainly important facts. That's all I got for you for now. Trust your gut. I'll see you in the comments.